Hello students, Sale of Goods Act and Consumer Protection Act Lesson 2. In today's lesson, let us focus on caveat emptor exceptions, transfer of property rules and exceptions, case laws related to transfer of property, unpaid seller, rights of unpaid seller, case laws related to unpaid seller. Let us focus on caveat emptor exceptions. Doctrine of caveat emptor. Doctrine of caveat emptor is Latin word which means let the buyer be aware. Let the buyer be aware. According to section 16, the first para is dealt with the caveat emptor as subject to the provisions of this act and any other law for the time being in force. There is no implied warranty or condition as to the quality or fitness for any particular purpose of goods supplied under a contract of sale. It means it is not the duty of the seller to highlight the faults in the goods. Instead, the buyer should be aware of the goods in terms of quality, fitness, and should carefully examine the goods before purchasing. Exceptions to the doctrine of caveat emptor. In case of misrepresentation by the seller, if the seller makes misrepresentation and the buyer readily believes on the representation, it is considered as an exception to the doctrine of caveat emptor. In case of concealment of latent defect by the seller, concealment of latent defect which is not found on reasonable examination by the seller is an exception to the doctrine of caveat emptor. In case of sale by description, section 15, when the goods are sold by the seller does not match with the description of the goods, it is regarded as exception to the caveat emptor. In case of sale by sample selection, section 17, when the goods are sold by sample and when the goods are supplied by the seller does not match with the corresponding sample, in such a case, caveat emptor is not applicable. In case of sale by sample selection as well as description, section 15, when the selling aspect takes place with the help of both sample and description but does not match with the supplied sample and description, it is considered as exceptional to the caveat emptor. Fitness for a particular purpose, section 16(1). When the buyers inform the purpose of purchasing to the dealer about the type of goods and completely relies on seller's decision or skills or judgment, in this situation, caveat emptor is not valid. Merchantable quality, section 16(2). The doctrine of caveat emptor is an exceptional case if the goods are purchased by description of the seller and there is an implied condition that goods should possess merchantable quality. Case law related to doctrine of caveat emptor. An old model car was purchased by Mr. X after possible inspection. After a certain time, the car bought is not the exact model as offered and proved to be even the oldest model. If the buyer refers the case to the court, what justice will be available to him? Mr. X will not get any justice in the court. As per the doctrine of caveat emptor, it is not the responsibility of the seller to reveal all the defects in the goods. The buyer should carefully examine the goods before buying. X cannot blame the seller for an old model car because it is the responsibility of Mr. X to check the car model before buying the car thoroughly. Transfer of property, rules and exceptions. Transfer of property. The term transfer of property refers to the transfer of ownership of the goods from one party to another. There exists a clear difference between the term transfer of ownership of goods and possession of goods. The term transfer of ownership means the transfer of ownership rights from the seller to the buyer, whereas possession of goods simply means the custody of the physical goods. The concept of transfer of property is explained in Sale of Goods Act 1930. In case of contract of sale of goods, the property or ownership of the seller in the goods is transferred to the buyer from the seller when the parties of a contract, buyer and seller, are willing to do so. The rules concerning transfer of ownership are designed on the basis of the assumption that the seller is either an absolute owner of the goods or is empowered to sell the goods, then and thus the sale made by the seller makes the buyer whom the goods are sold an absolute owner of the goods. If in case the seller is neither an absolute owner nor the empowered person, then the buyer will not be an absolute owner. Essentials of transfer of property. Risk linked to ownership. Section 26 of the Act states that unless otherwise agreed, the goods remain at the seller's risk until the property therein is transferred to the buyer. The goods are at the buyer's risk whether delivery has been made or not. In simple words, if the ownership of goods is transferred to the buyer, any damage to the goods would be borne by the buyer, even if he did not get the actual possession of the goods. Owner's right against third party. In case of any risk of damage or destruction of goods by any third party, the right to initiate action against third party only lies with the owner of the goods, even if he does not have the possession of the goods. Case of insolvency. In case of the buyer or the seller becoming insolvent, the ownership of goods is decided based upon the status of the ownership of goods before the insolvency. If the ownership belongs to the buyer before insolvency, he would be considered as the true owner of the goods. Let us discuss the rule regarding transfer of property. In case of contract of sale of goods, the property or ownership of the seller in the goods is transferred to the buyer from the seller when the parties of a contract, buyer and seller, are willing to do so. In case if the intentions of the parties are unknown, then the rules as per section 2224 of the Sale of Goods Act 1930 are applied. The rules are rules concerning transfer of property in case of specific goods, rules concerning transfer of property in case of unascertained goods, rules concerning transfer of property in case of specific goods. According to section 19, the property or ownership in specific goods is transferred from seller to buyer at the time when the parties of a contract wills to. The intention of the parties could be determined from the following: the terms and conditions of contract, the conduct of the parties of a contract, and conditions prevailing in the case. In case of specific goods, the following rules or applied to make decision about the intention of the parties, where seller's action is pending. According to section 21, in case of specific goods, the seller is supposed to perform something to bring the goods in a deliverable state. Then, under such a situation, the property in goods is transferred to the buyer only when the seller performs such action. Where goods are sold to buyer on sale or on approval or on a return basis, in case if the seller sells goods to the buyer on sale or approval or return basis, then the property or ownership in goods is transferred from seller to buyer only when any of the following conditions are met: acceptance of goods by the buyer carries out any action which is same as that of accepting the goods. Where goods are in a deliverable condition, according to section 20, in case of sale of specific goods which are in deliverable condition, the property of ownership in goods is transferred from the seller to the buyer immediately after the contract is formed, and acceptance from buyer on a condition that no contradictory intention is present in the contract in this regard. Where goods have to be measured, weighed, or tested, according to section 22, in case when there is a contract for sale of specific goods in deliverable condition, some activities like measuring, weighing or testing needs to be carried out by the seller before the sale in order to determine the exact or correct price of the goods. Then under such a situation, the property in goods will be transferred to the buyer after the completion of such an activity. Rules concerning transfer of property in case of unascertained goods, property or ownership in goods would be transferred from the seller to the buyer only after the ascertainment of such goods. Coming to the exceptions to the general rule of transfership, um, transfer of ownership, exceptions. Sale by person, not the owner, or sale by non-owner. Subject to the provisions of the Act, any other law for the time being in force, where goods are sold by a person who is not the owner and who does not sell them under the authority, the buyer acquires no better title to the goods. Sale by one of the joint owners. If one of the several joint owners of goods has the sole possession of them by permission of the co-owners, the property in the goods is transferred to any person who buys them. The buyer acquires a good title provided he buys goods in good faith and has no knowledge that the seller has no authority to sell. Sale by person in possession under voidable contract. When the seller of goods has obtained possession thereof under a contract voidable under the Indian Contract Act 1872, the contract was not rescinded at the time of the sale. The buyer acquires a good title to the goods provided the buyer buys them in good faith without the notice of the seller's defect of the title. Seller or buyer in possession after sale, where a person having sold goods continues or is in possession of the goods or of the documents of title of the goods, the delivery or transfer by that person or by a mercantile agent acting for him, the goods or document of title under any sale, pledge or other disposition thereof to any person receiving the same in good faith without notice of the previous sale shall have the same effect as if person is making the delivery or transfer were expressly authorized by the owner of the goods to make the same. When a person having bought or agreed to buy goods obtains with the consent of the seller possession of the goods or the documents of title to the goods, the delivery or transfer by that person or by a mercantile agent acting for him the goods or documents of title under any sale, pledge, or other disposition thereof to any person receiving the same in good faith and without notice or any lien or other right of the original seller in respect of the goods shall have effect as if such lien or right did not exist. Resale by unpaid seller. According to section 54, an unpaid seller might possess the goods in his custody in case he or she has exercised the right of lien or stoppage of goods in transit. A buyer who purchases goods from an unpaid seller will get a good title in spite of the fact that resale might not be justified in some situations. Title by estoppel. According to section 27, seller of goods in presence of the actual owner tells the buyer that he or she is the owner of goods and the actual owner keeps quiet, then the actual owner will lose the right to take away the ownership title or authority from seller. Sale of goods by pawnee. As per section 176 of the Indian Contract Act, if the pawnee sells the goods after the default of the pawner, then the buyer of such goods will get a valid title. Sale of goods by finder of goods. As per section 169, the Indian Contract Act, a person who had purchased goods from the finder of goods will get a valid title for such goods. Sale of goods by a person acting in execution of law. The goods sold by a person acting in execution of law or under power of sale will give a good title to the buyer. Sale of goods by mercantile agent. According to section 27, a mercantile agent is a person who possesses goods or any document of title of the goods with the permission of actual owner during the course of business. The buyer purchasing goods from mercantile agent will get a valid title on the condition that he or she acts in good faith. Case law related to transfer of property. B goes to shop and buys a sari thinking that it is kanchi sari. It turns out to be a cotton sari. Can he return the sari? If so, under what ground? No, B cannot return the sari because the doctrine of caveat emptor applies in this case. As per the doctrine of caveat emptor, buyer should be aware of the goods in terms of quality, fitness, and should carefully examine the goods before purchasing. A finds a car and after making reasonable efforts to discover the owner, sells it to B, who buys without knowledge that A was merely a finder. Can the true owner recover the car from B? Yes, the true owner can recover the car from B because the sale of car in this case is not a valid sale and B will not get a good title. This case does not come under the purview of sale by finder of lost goods. Reddy bought some jewelry from Kiran on sale or return basis. Reddy mortgaged the same with Prakash. After a certain time, Reddy returned the jewelry to Kiran. Kiran claims the goods are sold as they were mortgaged justify the case. Mortgage is not a sale. So Kiran cannot claim that Reddy had sold jewelry to Prakash. If Reddy had returned the jewelry to Kiran with a reasonable time or within the specified time, then Kiran should accept the jewelry. Unpaid seller, rights of unpaid seller. A seller is regarded as an unpaid seller in the following situations. When seller is left unpaid for the goods which he had sold to the customers, when a negotiable instrument is drawn with conditional payment and the conditions specified in the instrument have not been met due to dishonor or the instrument or other reason. These conditions should be met in order to declare a seller of goods as an unpaid seller. A seller of goods should not be paid and the price of goods should be due. A seller of goods should have quick right to claim for the price. A seller of goods must have received a negotiable instrument and the same needs to be dishonored. Rights of an unpaid seller. Rights against the goods. Rights against the buyer personally. Right of stoppage in transit. right against the buyer personally, right to sue buyer for price, right against the goods, rights of an unpaid seller against the goods, further classified into subcategories, rights of an unpaid seller where property in goods is transferred to the buyer, rights of an unpaid seller where property in goods is not transferred to the buyer, rights of an unpaid seller where property in goods is transferred to the buyer, right of lien, right of resale, right of stoppage in transit. Right of lien. A right of lien is a right to keep hold the possession of goods unless and until the price is paid for the goods. Right of lien is present for the unpaid sellers who has the possession of goods and is applicable under following conditions: when goods are sold without any specification with respect to credit, when buyer fails to pay the price of goods, uh, when goods are sold on credit and credit period crosses or expires. Right of resale. An unpaid seller can resale the goods under following conditions: when the goods are perishable in nature, when unpaid seller sends notice to buyer he wants to resale the goods and the buyer fails in making payment within the reasonable period. A seller can recover the loss incurred on resale of goods from buyer. When seller expressly states that he will have a right to resale the goods, buyer fails in making payment for the goods. Right of stoppage in transit. The right of stoppage in transit is the right of an unpaid seller to stop the goods which are in transit from reaching the buyer. Apart from this, unpaid seller has right to continue possession of goods till the goods are in transit to and retain possession of goods till the buyer makes payment for goods. An unpaid seller will have right of stoppage in transit in the following situations: when buyer fails to make payment, the goods are in transit. The right of stoppage in transit is an extension to the right of lien. An unpaid seller can avail his right of stoppage in transit, availing right by sending a notice to carrier or other bailee about his claim to get the payment for the goods, availing right by taking the possession of goods. Rights of an unpaid seller where property in goods not transferred to the buyer. Besides the other measures, the unpaid seller can have the right of withholding delivery, which he is the same as right of lien, and right of stoppage in transit where property in goods is not transferred to the buyer. Rights of an unpaid seller against the buyer are known as rights in personam. These include right to claim for damages for non-acceptance. If the buyer does not accept the delivery of goods and refuses to make payment for the goods, then under such a situation, seller can claim the damages which he had incurred due to non-acceptance by the buyer. Right to sue buyer for interest. The seller will get right to sue the buyer for the payment of interest if any agreement is signed by the buyer and seller regarding the payment of interest on the price of the goods. In this situation, seller will have the right to collect interest amount from the buyer from the date when the payment is due. Right to sue buyer for price. If the property in goods is transferred to the buyer and buyer refuses to make payment for the goods, then in this situation, the seller can sue buyer for the price of the goods. A seller can sue the buyer for price for the goods even if the property in goods is not transferred to the buyer and buyer has refused to make payment for the goods. Seller may consider the contract as dishonor and file a suit against the buyer to recover the damages for breach of contract. Let us discuss about the rights of a buyer and also the rights of a seller. Rights of a buyer: right to accept the delivered goods, right to reject the contract if the seller is responsible for breach of contract, right to possess a reasonable opportunity to scrutinize the goods, right to sue the seller in case of any damage in non-delivered goods if the goods are not delivered, right to recollect the money paid from the seller if he does not complete the contract or by delivering the goods, right to sue the seller for certain performance of the contract, right to sue the seller in case of any damages for breach of warranty. In case of breach of contract by the seller, the buyer has right to claim interest on the amount of price paid from the date of payment. Rights of seller: right to collect the price of the goods, right to obtain compensation or sue for the loss incurred by him because of buyer's rejection or by his neglecting behavior to accept the delivery of goods, right to obtain an appropriate charge for core concern and protection of goods, right to uh, exert his right of stoppage in journey, right to exert his right on lien, right to exert his right on right of resale, right to sue the buyer if he causes any damage or if he wantedly neglects or rejects the acceptance of goods, right to sue the goods price, right to recollect the interest from buyer in case of particular agreement to the effect given or to charge interest on the price in case of it turns out to be due, to sue buyer for damages and for rejecting the contract. Case laws related to unpaid seller. There was a sale of 25 tons of paper to be shipped in November. The seller shipped 20 tons in November and 5 tons in December. Can the buyer reject the whole of 25 tons? Yes, the buyer has the right to reject the whole of 25 tons of paper shipped to him because the sale agreement was to ship 25 tons of paper in November. However, the seller did not follow the details of the contract and shipped 20 tons of paper in November and the remaining 5 tons of paper in December. Under section 37, the buyer has the right to reject the goods where the seller delivers a lesser quantity of goods than what was mentioned in the contract. Ram sells a horse to Rahim without disclosing the fact that the horse was unsound. Can Rahim cancel the contract? No, Rahim cannot cancel the contract as the silence of Ram does not amount to fraud. Here, the principle of caveat emptor is applicable. As per the doctrine of caveat emptor, buyer should be aware of the goods in terms of quality, fitness, and should carefully examine the goods before purchasing. This principle also states that it is not the duty of seller to highlight the faults in the goods. X sells and consigns goods to Y. X being still unpaid, Y becomes insolvent while the goods are still in transit. Y assigns the bill of lading for cash to Z, who knows that Y is insolvent. Can X stop the goods in transit? Yes, X can stop the goods in transit as X is unpaid seller and Y has become insolvent while the goods are in transit. A purchased milk from a shop. It contained typhoid germs. His wife consumed the milk and got affected with typhoid. What remedy can he claim from the shopkeeper and under what grounds? The remedy for A is that he can claim reasonable damage from the shopkeeper under the ground breach of condition as to wholesomeness. A finds a gold ring and after making reasonable efforts to discover the owner, sells it to B, who buys without knowledge that A was merely a finder. Can the true owner recover the ring from B? Yes, the true owner can recover the ring from B because the sale of ring in this case is not a valid sale and B will not get a good title. This case does not come under the purview of sale by finder of lost goods. A contract was created to buy certain goods to be imported from Singapore. The purchasing party paid the total amount in advance. The stock damaged due to seawater and lost merchantability. Can buying party claim advance back? Yes, the buying party can claim his advance back as the buyer has paid the total amount in advance. Moreover, according to law, the seller is required to pay the amount to buyer in case if goods are damaged during a delivery. Thank you very much.